Hello friends, welcome back to my channel. Today I am going to discuss about acceptance under the Indian Contract Act. In my last video I had discussed proposal under the Indian Contract Act, and today I will be discussing acceptance. So let's start. An agreement arises when a proposal is accepted. So it is only after the acceptance of a proposal that a contract between the party can arise. Section 2B of the Indian Contract Act says, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. So, from the definition under section 2B, we can say that the person to whom the proposal is made, if signifies his assent thereto, that means if he accepts the proposal, then that proposal is said to be accepted. And a proposal when accepted becomes a promise. For example, if A makes an offer to B, so A is the offerer and B is the offeree, and now if B signifies his assent to the offer, that means if B conveys to A that he accepts that offer, then that offer or that proposal is said to be accepted. Now when B accepts the proposal given by A, then that results in a promise. So this is how an agreement arises between parties. So I am repeating once again, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So when an offerer makes a proposal to the offeree and the offeree conveys his acceptance to the offerer, then that proposal is said to be accepted, and a proposal when accepted becomes a promise. Now effect of acceptance, or we can say effect of valid acceptance. Now what happens when an offer is accepted? As we have studied, an offer or proposal when accepted becomes a promise. So a contract is created only after an offer is accepted. Before the acceptance of the offer, neither party is bound thereby. At that stage, the offerer is free to revoke or withdraw his offer. Before, suppose A makes an offer to B to sell his radio set. Now B has not accepted that offer. Till the time B accepts the offer, or prior to that, that means before B accepts that offer, A is free to either withdraw or revoke his offer, and the offeree is also free not to accept that offer or to reject the same. So until the offer is accepted, neither party is bound thereby. Even the offerer can withdraw or revoke his offer before the acceptance, or even the offeree can say no to accept that offer, or he can reject the offer. So before the acceptance, neither party is bound by the offer. After the offer has been accepted, it becomes a promise which, if other conditions of a valid contract are satisfied, binds both the parties to the promise. So after acceptance, each party to the contract or agreement becomes legally bound by the promise made by him or her through the medium of offer and the acceptance of that particular offer. So the effect of acceptance is that the acceptance of the offer binds the parties to the agreement. Now coming to essentials of a valid acceptance. In order that acceptance of an offer can result in a contract, the acceptance must satisfy certain requirements. Now what are these requirements? We will be discussing one by one. First essential of a valid acceptance is that the acceptance should be communicated by the offeree to the offerer. So the offeree must signify his assent. Signify his assent means the offeree must communicate the acceptance to the offerer. The communication of acceptance is deemed to be made by any act or omission of the party accepting the offer. Suppose if the parties are physically present in front of each other, then the communication of the acceptance of the offer can be oral. But when the parties are at a distant place, the communication should be made by post, by telegram, or by a message on phone, through a messenger, or any other reasonable manner. So in order to create a contract, acceptance of the offer and the intimation of the acceptance of that particular offer is very much necessary. So the first essential of a valid acceptance is that the acceptance should be communicated by the offeree to the offerer. Now, the second essential element for a valid acceptance is that the acceptance should be absolute and unqualified. So, the acceptance must be absolute and unqualified. It means that the acceptance should be made in such a way that there should not remain any further thing for negotiation. There should be no scope for further negotiation. When the acceptance contemplates any future negotiations between parties for the finalization of the terms of the contract, then there arises no contract. So the acceptance should be absolute and unqualified. Third essential of a valid acceptance is acceptance should be made in some usual and reasonable manner unless the proposal prescribes the manner of acceptance. It means that if the manner of acceptance of the proposal has been prescribed by the proposal, then the acceptance has to be in that prescribed manner. Otherwise, the acceptance of the proposal may be made in some usual or reasonable manner. So, the usual and reasonable manner of acceptance here means the manner which is usually adopted in a particular kind of transaction according to the usage or custom of trade. Generally, acceptance by post, telegram, telephone or through personal messenger may be considered to be some usual manner of acceptance of proposal. And the fourth essential of a valid acceptance is that acceptance should be made while the offer is still subsisting. As we have noted earlier, that the offerer is free to withdraw the offer or the offerer is free to revoke his offer. So, after the offer has been withdrawn or has left, there is nothing that remains which can be accepted. So, it is very much necessary that the offeree makes the acceptance while the offer is still subsisting or while the offer is still alive. The acceptance of an offer after the lapse of that particular offer cannot give rise to any agreement or contract. So, for a valid acceptance, the acceptance of the offer should be made while the offer is still subsisting. These were the four essentials of a valid acceptance under the Contract Act. Now, coming to revocation of offer and acceptance. First, let us do revocation of offer. The word revocation in a general sense, it means to nullify something. However, when we are talking about revocation of offer, it means the withdrawal of an offer by the offerer. And that withdrawal of the offer must be made before the acceptance of that offer by the offeree. It is only after the acceptance of an offer that there arises a contract between the parties and the parties becomes bound by their respective promises. So, before the offer is accepted, it can be revoked. However, if the offer is accepted by the offeree, then it ripens into a contract and the offer cannot be revoked by the offerer. According to Section 5, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposal but not afterwards. So, as per Section 5 of the Contract Act, an offerer may revoke his proposal any time before the communication of its acceptance is complete as against the proposer but not afterwards. So, we can see that Section 5 uses the words before the communication of its acceptance is complete as against the proposer. So, communication of its acceptance is complete as against the proposer. It means when the offer is placed in the course of transmission to the offerer. So, when the acceptance is placed in the course of transmission to the offerer, the proposal or the offer cannot be revoked by the offerer. But before the acceptance is placed in the course of transmission by the offeree, before that the offerer may revoke the offer. So, as per Section 5, a proposal or the offer may be revoked at any time before the communication of its acceptance is complete as against the proposer but not afterwards. That means the offerer may revoke the offer before the communication of the acceptance by the offeree is placed in the course of transmission to the offerer. Now coming to section 6. Section 6 of the Contract Act mentions about various modes of revocation of offer. As per section 6, the first mode by which a proposal can be revoked is by the communication of notice of revocation by the proposer to the other party. So, as we have studied earlier, an offer ripens into a contract after it is accepted. But before the offer is accepted, the offerer is free to revoke the offer as there is no legal obligation that has arisen between the parties. So, now to revoke the offer, the proposer or the offerer may send a notice of revocation to the other party, that is the offeree. So, the offerer must send a notice of revocation to the offeree. So, this is the first mode by which proposal can be revoked, that is by the communication of notice of revocation by the proposer to the other party, to the offeree. The second mode by which the offer may be revoked is by the lapse of time described in the proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without acceptance of the proposal or without communication of the acceptance of the proposal. If the proposal prescribes certain time of acceptance in the proposal, then the offeree or the other party must accept the proposal within that prescribed time. If the offeree does not accept that proposal within that prescribed time, then the proposal is revoked by the lapse of time prescribed in that particular proposal for its acceptance. But if no time is so prescribed in the proposal, then the proposal is revoked by the lapse of a reasonable time without communication of acceptance. Non-acceptance within a reasonable time means an implied refusal by the offeree to accept the offer. So, the second mode by which an offer is revoked is by the lapse of time. The third mode by which the offer is revoked is by the failure of the acceptor to fulfill a condition precedent to acceptance. This mode applies to only those proposals or offer which are subject to some condition precedent for acceptance. So, when the offer is subject to some condition precedent and such condition has got to be fulfilled by the acceptor before making the acceptance. However, if the acceptor fails to fulfill that particular condition to acceptance, then the offer stands revoked. Then the offerer may revoke the offer. The fourth mode by which an offer can be revoked is by death or insanity of the offerer. So, an offer is revoked by the death or insanity of the proposer if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. So, it means that if the fact of the death or insanity of the proposer has not come to the knowledge of the offeree before the acceptance of that particular offer, then it is a valid acceptance and that may give rise to a contractual obligation. I am repeating the four modes of revocation of offer in a nutshell. The first mode by which a proposal or an offer can be revoked is by the communication of notice of revocation by the offerer or the proposer to the other party. The second mode of the revocation of offer is by the lapse of time described in such proposal for its acceptance, or if no such time is so prescribed by the proposal, then by the lapse of a reasonable time without a communication of the acceptance of the proposal. The third mode by which a proposal can be revoked is by the death or insanity of the proposer, if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. And the fourth mode by which offer or the proposal can be revoked is by the failure of the acceptor to fulfill a condition precedent to acceptance. So, these were the four modes of revocation of offer. Now, coming to revocation of acceptance. As per section 5 of the Indian Contract Act, an acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. So, as per Section 5 of the Contract Act, an acceptor may revoke his acceptance at any time before the communication of the acceptance of the proposal reaches the offerer or the proposer. So, before the communication of the acceptance of the proposal is completed as against the acceptor, that means before the communication of the acceptance of the proposal reaches the offerer or the proposer, the acceptor may revoke the acceptance. So, this is all about revocation of acceptance of proposal. So, this was all about acceptance under the Indian Contract Act. In my next video, I will come up with another important topic from the Indian Contract Act 1872. If you like the content of my videos, please subscribe to my channel and do like and share my videos. Thank you for listening.